time when filing a PIL was an act of rebellion, a call for justice by those who had nothing but their voice. But today, something shifted. The courtroom has become a stage, the petition, a press release, and the public interest swallowed by public image. I am Amol Dhudi, advocate on record, and what I am about to say might not win me applause, but it will protect the Dharma of our Constitution. This isn't a takedown of PILs, it's a wake-up call for every lawyer who still believes the law is sacred, for every citizen who wonders why real justice seems slow, and for the system that's slowly being bent into spectacle. Let's begin at the root. Public interest litigation was never meant for the elite. It was a crack in the gate of justice meant for the voiceless, the powerless, the invisible. It gave standing to those who had no status. It gave speed to those trapped by delay. But today, PIL has become the shortcut of the spotlight generation. Filed not with truth, but with trending hashtags in mind. I've seen both sides, the real PIL that saves lives and the PRIL, the public relations litigation, filed for panels, clout and the cameras. When I speak now, I don't speak to impress. I speak as a soldier of this constitution. I speak for the cause that brought me to the bar, not for fame, not for optics, but for fire. In this lecture, I'll take you through the original sanctity of PIL, how and when the system started to break, why media, influencer and even lawyers have gamified the law, and most importantly, how we take it back. I'll name patterns, not names. I'll expose pathology, not personalities, because the disease is bigger than any one person. It's the erosion of intent behind the legal process itself. PIL was born in fire. It must not die in the vanity. So if you are here for gossip, go elsewhere. But if you are here to remember what justice feels like when it's raw, unscripted and true, stay with me. We begin now, not with judgment, but with ruthless clarity. Before PIL became fashionable, it was revolutionary. Public interest litigation was not a loophole. It was a breakthrough. Born in a time when the legal system felt distant to the poor, PIL emerged as a bridge between constitutional rights and ground realities. Justice P.N. Bhagwati, criticized later for many things, will forever remain one of the sacred architects of this shift. He, along with Justice V.R. Krishna Iyer, ignited a new possibility. That slogan standee, the right to bring a case, should not depend on a privilege, but on principle. Let's look at the kind of cases that define early PILs. Bonded labor, environmental, destruction, custodial violence, the right of under-trial prisoners, the plight of payment dwellers. These weren't campaigns, they were cries for justice, and PIL was the sword of Dharma, wielded by the court to protect the unprotected. These weren't filed with media in mind, they were filed in agony and often in anonymity. Legally, it widened standing. Spiritually, it purified the purpose. In spirituality, the first principle is intention is power. So long as PILs were filed with pure sankalp, pure constitutional will, the system responded with force. The courtroom became a temple of equity, not just for litigants, but for ideals. PIL wasn't an instrument of fame. It was a fire ritual, where the petition was the offering and justice was the smoke that rose. Bhagwati didn't want lawyers turning into social media saints. He wanted the judiciary to be an agent of transformation. Access to justice cannot be denied to the poor, illiterate and ignorant. That was Bhagwati's call, not for litigation, but for Lok Nyaya, people's justice. His vision was not of courtroom theatre, but of legal compassion, of righteous accuracy and urgency. The origin of PIL was sacred, and when something sacred is exploited, it becomes dangerous. We don't protect Dharma by romanticizing the past. We protect it by honoring the spirit behind the form. So before we critique what PIL has become, we must remember what it was. Because to revive Dharma in the courtroom, you must first recognize when it left. This is no longer the courtroom, this is the stage. Today, a PIL is not just filed, it's launched, accompanied by press releases, Twitter threads, podcast interviews and Instagram theories. The cause is no longer the center, the litigant is. There is no new species of legal actor, the PIL performer, more concerned with trending than truth, with optics than outcome. PILs today often act less like petitions and more like publicity. Missiles launched at political targets. Let me give you some patterns we now see repeatedly. 1. Political proxy PILs. Filed not by stakeholders but by unknown proxies with shadow funding. Their goal to ignite controversy. Second, media first PILs. Drafted in silence but published in media before being filed in court. The aim, control the narrative, not the law. Third, sensation over substance. File a PL on a hot issue, often knowing it will be dismissed, but the aim was never the verdict, it was the virality. Remember, in the Tantrika understanding, what begins with impure intention rots the result. A PIL filed to seek applause corrupts the force of justice. You have now weaponized the courtroom for ego. And Dharma, when mocked for attention, doesn't fade. It retaliates with delays, with confusion, with karmic erosion of public trust. Here's the hard truth. Law was never meant to be content. When the lawyer wants followers more than facts and the courtroom becomes a real, everyone loses. You lose credibility. The judiciary loses sanctity and the citizen loses faith. PIL became a puppet show and the constitution its silent backdrop. This is no longer about rights, it's about reach. But the more we fake justice for likes, the harder it becomes to achieve it in reality. Performance PILs are not a harmless trend. They are termites, and the house of justice is crumbling from the inside. When a PIL goes viral, ask not just who filed it, ask who benefits from it. In the shadows of litigation, power brokers hide. True PILs seek relief for the marginalized. But PR litigation, it seeks leverage. Who gains when institutions are put on trial via hashtags? Who profits when courts become battlegrounds for ideological warfare? The answers aren't always on the case title. They are behind the curtain, media handlers, political strategists, and international lobbies. There's a new power player in Indian litigation, the NGO litigation complex. Well-funded entities, often backed by foreign or elite urban interests, file PILs not to protect the constitution, but to pressure it into submission. They target symbols, temples, military policy, national agencies, and cultural norms, not for justice, but for ideological control. When you can't win elections, you try to win in the courtrooms. When you can't build people's trust, you try to shake institutions from inside. PILs are not used as delay tactics, reputation sabotage tools, or to create moral panic around government action. And the tragedy is, some courts, in their eagerness to appear progressive, unknowingly reward these tactics. Every PR mask PIL consumes the court's time. Every dramatic filing delays a real one. And the ones who suffer, the farmer who can't get compensation, the woman waiting on a maintenance order, and the honest citizen trying to enforce their rights. The court becomes a theater of image, not a temple of law. This isn't a justice. This is narrative warfare in the name of justice. When you hijack the constitution to stage your relevance, you don't uplift the law, you defile it. And make no mistake, this distortion has consequences, not just on the legal system, but on the soul of the republic. Courts are never meant to be platform for spectacle. They are sacred instruments of balance. But today, thanks to the rise of PR litigation, the judiciary is under siege, not from the outside, but from within. Every frivolous PIL filed for the camera drags the court into political pit. It compels judges to rule on trends rather than truths. The Indian judiciary is already burdened over 5 pending cases, and yet well-scripted, media-backed PILs leap from over thousands of urgent matters. This is not justice, it's distortion. It's legal queue jumping by those who understand the PR game, not the constitution. When courts become regular players in news cycles, when judgments are anticipated like IPL matches, what happens to impartiality? Judges too are human under constant public or media scrutiny, public shaming or glorification. They risk being influenced not by law but by the noise. This subtle corruption is worse than bribery. It is emotional manipulation of the highest seat of Dharma. The moment the people begin to believe that courts only hear the powerful, the loud, the well-funded, faith in the system collapses. When justice is seen as a tool for image building, not truth seeking, the citizen no longer knocks on the court's door with hope. He walks away in silent despair. And a democracy where citizens stop believing in justice is a democracy on a ventilator. The court must remain an altar of seriousness, not a stage for fame seekers. PIL was born from the womb of Dharma to fight for those with no voice. Today we must reclaim it from those who use it as a brand leader. Because a judiciary that bends to applause can never stand tall in the face of injustice. Let's be honest, most PRPILs aren't about justice. They are about relevance, recognition, and control. The modern PR litigant doesn't see the law as a tool for resolution. He sees it as a mirror, reflecting his own moral superiority to the world. This isn't advocacy. It's vanity dressed in robes of public concern. There's a predictable pattern. They pick emotionally charged topics. They time the petition with breaking news and they leak it to the media outlets before it's even mentioned in the court. This isn't about truth, it's about curating the perfect narrative. They don't want the law to speak, they want to be seen as the law. PR litigants are performance addicts. They don't seek outcomes, they seek optics. Notice how many of them never follow up on their petitions. Once the limelight fades, so does their activism. Justice requires grit. They only bring glamour. One of the most dangerous tactics, weaponized victimhood. They present themselves as lone warriors against the system. But in truth, they are well networked with media, NGOs, and narrative strategists. The poor me tone is just a shield. Behind it is a sharp campaign to hijack public emotion and court time. It's not about fighting for the voiceless. It's about positioning themselves as heroes in a false drama. To fight injustice is sacred. But to fake it for fame, that's violence against Dharma. PI was not born to be a photo op. It was born to break the conscience of the court. Even when the secret mechanism is hijacked by those who crave applause, more than impact, we must call it out. Because silence here is not neutrality, it's complicity. What was once a sacred judicial mechanism is now a launchpad for prime time panels. Petitions are no longer filed for the courts, but for the cameras and the news channels. The PIL is drafted with the media lens in mind. Headlines are embedded in the prayer itself. The courtroom becomes a set, the bench becomes a stage, and the petition becomes a script. There's now a media litigant industrial complex. Influencer lawyers and legacy media outlets feed off each other. Petitioners seek documents to newsrooms and media offers platform time in exchange for exclusives. It's not justice, it's a joint PR. This isn't about public interest, it's about mutual amplification. The judiciary is not blind to this. Many benches have called out frivolous PILs, but the cycle still continues. Why? Because the cost of fake PIL is still less than the media returns they generate. It's a crisis of incentive, not law. Until the cost of such media stage litigation exceeds the fame it offers, the abuse will continue. In this ecosystem, who really holds power? Not the judges, not even the constitution. It's the media barons, influencer lawyers, and narrative architects. They decide what the public sees, they spin the meaning of judgments before they are even uploaded. Law becomes perception management, not jurisprudence. You don't just need law reforms, you need narrative reforms also. This nexus must be broken with truth, not trend jumping, with ethics, not ego. Because if law becomes a theater of self-promotion, then who protects the voiceless? When you cheapen justice for airtime, you don't just harm the court, you harm the constitutional soul of Bharat. We have seen how PILs has been hijacked. Now the question is, how do we save it from ourselves? How do we rebuild the filter so that only genuine flames pass through? First, the court itself must raise the drawbridge before a petition even gets numbered. Pre-admission screening panels must be mixed benches that include social activists, subject matter experts, and retired judges. A stricter cause of action review, no petitions without clear locus, no photocopied generic phrase of public interest. Mandatory cost notices. Every petitioner must acknowledge, I understand that if this petition is dismissed as frivolous, I may be penalized. These aren't bureaucratic hurdles. They are sacred thresholds designed to keep the fire pure. In the Supreme Court, only an advocate on record can file a petition. That status is not just a privilege, it is a vow of responsibility. AOR duties must be elevated. 1. Ethical vetting. Confirm the petition's true public purpose, not client convenience. 2. Fact checking. Interview real stakeholders. No anonymous second-hand claims. 3rd. Accountability. Sign a personal declaration. I affirm this petition is in genuine public interest. When your AOR signs, he or she is the first guardian of the temple. Let that oath mean something. Judges must reclaim their role as custodians of constitutional intent. This means 1. Active case management. At the first hearing, the bench asks, is this petition cause-driven or cloud-driven? 2. Inherent powers. Use Order 41, Rule 27, power to strike down petitions, not sparingly but strategically. 3rd. Cost orders by default. If a petition appears to be the PR litigation, impose cost immediately. No mercy for misuse. 4. Periodic review. Quarterly hearing or PIL pendency and purpose, so the court never loses sight of its original mission. The bench must be both the gate and the guardian, letting in only what serves justice. Finally, we lawyers must become the watchdogs of each other. Let's talk about Bar Council codes. Bar Council must expand the professional misconduct rules to include frivolous public interest litigation as a punishable offense. Ethics Committee fast-track complaints against advocates who treat PIL as PR. Peer accountability. Senior counsel must mentor juniors. No applause for empty gestures. Public registry. Publish a list of petitions flagged for misuse. Let transparency shame the shameless. If we don't police our own, no court order can save the system. These reforms are not optional. They are the pulse points of living constitution. Strong filters, vigilant guardians, assertive gatekeepers, and a self-policing profession. This is how we reform from within. This is how we reclaim PIL as a sacred fire it was meant to be. If you're serious about justice, stand with me, because every petition you file for applause denies someone the relief they deserve. Let's rebuild the temple of justice, not with slogans, but with seal-forged integrity. If PIL is to survive and serve, it must not be crowd pleaser. It must be warrior's tool, blunt, precise, and unafraid of sacrifice. This is your manifesto for real public interest litigation. Before you draft your prayers, ask, is there no alternative remedy? If there is a simple remedy, the PIL fails its purpose. Does the cause impact the marginalized? If the victims can afford an advocate, this isn't a PIL. Is there concrete evidence? No hearsay, no conspiracy theories, hard facts only. Will delay harm real people if waiting for electoral or administrative relief? Hurts lives, you have urgency. Is the motive selfless? If even a hint of applause lurks behind a petition, you must step back. Embody these 5 warrior ethics in every PIL. 1. Truth over trend, courage to file without cameras. 2. Urgency over optics. Act now, speak later. 3rd. Dispassion over drama, let the law speak, not your ego. 4. Shield for the weak. Your petition must build bridges, not banners. 5. Accountability over applause. Be ready for cost, criticism, and consequences. To the young advocates, don't chase headlines, chase impact. File one true PIL that changes a life, then speak. Earn the silence of the court before seeking the noise of media. Let your first victory be unseen, your first impact uncelebrated. Then let your work speak volumes. This is your warrior's vow. I will file only for voiceless. I will speak only for truth. I will face penalty rather than compromise purpose. I will serve the Constitution without fear or favor. This manifesto is not optional. It is the contract between you and the highest ideals of justice. Sign it with your life. Then step into the court and remember who you serve. We began this journey standing in the ruins of PIL's promise. We traced its sacred birth, watched its corruption, and fought to reclaim its soul. Now at the end of this lecture, one truth remains. Law will remember who you served. We saw how PIL emerged as a beacon for the powerless, how it was twisted into a spotlight for the powerful. We named the disease performative petitions, media collusion, and hidden agendas. We charted the cure, filters at the gate, guardians in the chambers, judges as sentinels, and a self-policing bar. We forged a manifesto, the warrior's code of true PIL, truth before trend, urgency before optics, accountability over applause. Justice is not abstract. It is a lived cause of every filing, every argument, every judgment. If you file a PIL for clout, you betray those still waiting at the gate. But if you file for the voiceless, you strike a blow for every citizen. Today I call on you, lawyers, judges, students, citizens, to make one vow. I will serve justice, not my image. I will uphold the Constitution, not my convenience. I will bear the burden of truth, even if it brings cost, criticism, and chaos. Because only those who serve with sacrifice earn the right to wield the law. This flame is your witness. It will burn away your half measures, your compromises, your hidden motives. Carry it with you into every chamber, courtrooms, council conversations. Let it light, guide your petitions, your presence, your power. Law will remember who you served. History will keep its receipts, and the Republic will reward its true guardians. If you stand with this cause, share this video. Join the movement. Subscribe for more fearless commentary, and together we will restore the fire of Indian justice. This is Amod Vidhuri. Thank you. Jai Hind.